back to the Morning Brief right here on Channels Television. So it's time now to delve into that Supreme Court decision by the three-man panel affirming the Martin Amewule-led assembly. But remember that this case has to do only with the presentation of the budget from last year, 2024. There are other matters that would be decided later on, particularly on whether or not, they are still members of the PDP. And that is, the contentious issue that many are still looking forward to. But what is the implication of this judgment by the Rivers State House of Assembly? Let's get right into by the court, the Supreme Court rather. Let's get right into the discussion this morning. And we have joining us Mr. Henry Ekine, a legal practitioner and National Legal Advisor of the Committee for the Defense of Human Rights, CDHR. He joins us virtually from Port Harcourt. Good morning, and thank you so much for joining us on the program.
Good morning, and thank you for having me. It's my pleasure to join you.
Yeah, and so let's just start with a setting out of how you received and are perceiving this particular judgment by the three-man panel of the Supreme Court.
First, I think I would need to, maybe on the legal understanding, straighten some issues. I wouldn't quite say that the Supreme Court made any judgment yesterday. Matters were before the Supreme Court for hearing. And one of those before the hearing was sought to be withdrawn. And then the others went on for hearing. And judgment for those that were heard reserved for a later date, when the Supreme Court will communicate to the parties, perhaps through their counsel, when the judgments will be ready. Some may be confused, so what is this talking about? That the Supreme Court said something when the notice of withdrawal was brought to its notice in the court. That was a ruling, not quite a judgment. But I wouldn't want to bore the viewers much as to the difference between a judgment and a ruling. Having said that, it came to me as not really any serious concern, understanding that a litigant, let's say if it were a trial court, the claimant, or here in appeal, the appellant, has a right to discontinue or withdraw his appeal at any time before judgment. And that's simply what I think that the appellant in that case, the governor of Rivers State, did by filing the notice of withdrawal of that particular appeal. And in most cases, you don't even need to espouse the reasons for your withdrawal. It's a simple one-line or two-lines notice to that effect. All you're required to do by the rules, file that, serve on the parties, serve on the court, and then you tell the court you're no longer continuing on that appeal. And then the court will accordingly dismiss it. And where certain steps have been taken, then based on the discretion of the court, may award cost against that appellant. So that was exactly what happened with respect to that particular appeal that emanated from the judgment of Justice Omotosho of the Federal High Court and got to the Court of Appeal when the Court of Appeal last year upheld that judgment of Justice Omotosho that was delivered in January of 2024. So that's legally and understanding the judicial processes and proceedings, exactly what happened yesterday. Yes, I understand that interpretations and drawing implications have always been whenever a judgment or a ruling, particularly in political matters, had been made by one court or another. So the same thing yesterday, after that withdrawal by the appellant, the governor of Rivers State, there have been a number of constructions and, if you like, interpretations of the implication of that withdrawal. I think for me, it's straightforward that the implication of a withdrawn appeal is that the appeal dies and ends at that stage. That's the primary implication, just like every other claim at a trial stage. If the claimant withdraws or discontinues his claim, it ends and, of course, absolves the defendant of any further step, except where they have a counterclaim. in this case, absolve the respondents, except where they have a cross appeal. Then they can continue their own appeal. But a further implication of that, if it's on appeal as it is now, will mean that the appellant who sought to challenge the decision of the lower court has exercised his right not to further challenge and leaving that decision of the lower court as the valid and subsisting decision.
So, Mr. Henry, should we be excited about, should we be enthusing about this particular dismissal, particularly because, rightly noted, the governor's lawyers had gone ahead to withdraw that case because time had elapsed over it. But remember that the Rivers State government has presented the 2025 budget of over 1 trillion naira. And, you know, the budget for 2024 had been expended. So should we be enthusing that the judiciary has done something remarkable in this particular dismissal?
Yes, again, I would say it's not much about what the judiciary has done. It's about what the appellant did. Because in this case, it's just to liken that the judiciary really didn't do much. Where the judiciary would have done something would have been when an appeal was heard. And then you examine the positions of both parties, reviewing the appellant's brief and the respondent's brief. Then we would have examined at that point what the judiciary would have done. But now, I think what is important here is the 2025 appropriation law has no contention at all. I am not sure, to the best of my knowledge at the moment, that anybody has instituted any action, of course, which would have been at the trial stage, against that appropriation law, whether the validity or otherwise of that law, or the procedure or passage of that law. So the 2025 appropriation law of Rivers State of 1.1 trillion naira is sacrosanct and has no bottleneck whatsoever, has no challenge or dispute over it whatsoever, and it has taken effect. It has commenced, and enforcement or implementation of that law has begun, and I don't think there's any challenge. So let's retract to 2024. The 2024 financial year, which began in January of 2024 and lapsed in December of 2024, has become history. If it were a human being, it's been interred. It has died and passed and has been buried. So the implementation of that law, or if you like, the execution of the projects that were contained in that appropriation law have long been concluded. I am not sure in the case of appropriation laws that they transmit, or in fact, they go beyond the financial year. Appropriation laws are unique. They are different from other legislations in the sense that they subsist only for that financial year. And that is why year on, you make another appropriation law. So the 2024 law that was specifically referenced by Justice Omotosho, and which was a subject of that litigation, has been spent. And time and circumstance have overtaken that particular subject matter. So it becomes what lawyers would say, and I think that was also what the counsel to the governor, the appellant, further interpreted when they granted interview. The reason behind their withdrawal, that it had become an exercise that you would barely describe as an academic exercise, a wasting of the time of the Supreme Court that is already overwhelmed with a number of matters before it to determine. So it was only wise that any appellant who has a matter before an appellate court, and clearly the matter has become a mere academic exercise, you discontinue it. It happens even in the trial courts. So it's not the 2025 appropriation law that is referred here. And the judgment of Justice Omotosho with respect to the appropriation law of 2024 in Rivers State has got nothing to do with 2025 appropriation law. It's not a judgment in perpetuity that will continue to affect every appropriation law in Rivers State, and God forbid, I will say.
All right, Mr. Henry, so we can talk about politics, we can talk about legal attrition, but let's stay with the context of what the ruling has to be. In practical terms now, and I want you to give your own view as far what this means. Of course, Appropriation Act is time-bound, but there are also components within Appropriation Act that can be passed on, like the capital component and all of that. But perhaps, if I'm right, help me if I'm wrong here, the ruling has clearly said that the right persons to do business with as at the time, based on Justice Omotosho's ruling or judgment, is Amewule led House of Assembly. That is what I understand to be what played out in court yesterday, given that withdrawal, because you've also said that the appellate court's decision referencing the trial court decision becomes a subsisting judgment of the court, and that is how we abide by it. So what happens to whatever was done as at a time by the governor and any other person besides appropriation law? Because I know there were issues of vetoing him and all of that. I can't go to all the details. What happens in the eyes of the law? Let's say this is purely academic, it's time-bound, it's gone and taken away. I'm talking about the appropriation. But what about every other business of the day? Because it looks like the judgment said that is the right person, or those are the right people to do business with government and legislature. Help us out here.
Yes, I think this will clearly be addressed by going back to the matter that was brought before Justice Omotosho. And permit me, it may take a bit of time to analyze this, so we understand my view and my position in that regard. When Martin Amewule, in November of 2023, at the time he was the Speaker of the River State House of Assembly, that's important, that's number one. So when he instituted this action before the Federal High Court on the 29th of November, he was the Speaker. So he instituted the action. River State House of Assembly was the first plaintiff, and Martin Amewule as the second plaintiff. It's important to even attempt to identify the defendants in that suit. The defendants from number 1 to 10 were the National Assembly of the Federal Republic of Nigeria, the Senate President, the Deputy Senate President, the Speaker of the House of Representatives, the Deputy Speaker of the House of Representatives. But before that, the majority leader of the Senate, the minority leader of the Senate, the same in the House of Representatives, down to the clerk of the National Assembly. Then from 11, the 11th defendant was the governor of River State, and of course the Attorney General, the Commissioner for Finance, the Accountant General, the River State Civil Service Commission, and Right Honorable Edith here. The reason I took out these parties is to let you understand what it was that the Martin Amewule approached the court for. It was a preemptive action. He wanted to stop the National Assembly from taking over the proceedings of the River State House of Assembly. He was afraid that the governor of River State was going to approach the National Assembly. So that was why you had those defendants from 1 to 10. Beyond that, he also had thoughts that the River State government, the executive, were going to withhold their funds. So he sought the order of court to restrain the governor from withholding their funds. And again, when it became clear by the 11th of December 2023, they defected, himself and 26 other colleagues of his defected. So remember that in November 19, 2023, when the action was instituted, he was the Speaker. So when Justice Omotosho had this matter before him to entertain, of course it was only reasonable that the River State House of Assembly that was appropriate would have been that was under Martin Amewule. But it is only reasonable as well to be pragmatic, and judicial activism will require that when Martin Amewule lost his position in the House of Assembly and was no longer a Speaker, progressing to December 2023, you can't expect that the governor of River State or the River State government will go to Martin Amewule's house and request of him to perform the functions of the Speaker of the House of Assembly when we had another one, or to make nominations and take to Martin Amewule. That was the critical disconnect that I think that we have to scrutinize in that judgment. And there are subsisting matters before the Federal High Court that deal particularly with the question of defection and the fate of Martin Amewule as a member of the River State House of Assembly before we even talk about his speakership.
All right.
So moving forward, when the River State government proceeded in December 13th to present the appropriation bill then to the House of Assembly, we have just one House of Assembly established by the Constitution. But at that time, under the speakership of Right Honorable Edison here, it's considered appropriate.
All right, Mr. Kennedy.
So when Justice Omotosho went on in January to deliver judgment as if he was retracting to 29th November 2023 when Martin Amewule was Speaker, I don't fault Justice Omotosho, because the processes before him showed that Martin Amewule at the time was the speaker.
All right.
So if he held that Martin Amewule's victory, supposed victory, by virtue of that judgment, was impeded, impeached, questioned, and of course made nugatory by his action of December 2023.
All right, Mr. Ekine.
Of which there are matters that are subsisting, challenging his membership, which himself is defending.
We appreciate the backstory you've given and this, chronicling of the events. But in other words, the struggle continues. Is that what you're saying?
Oh, well, it's unfortunate, but it does appear that we await the actual decision of the Federal High Court or Nigerian judiciary with respect to the critical question and the fundamental issue of the defection of 27 former members of the Rivers State House of Assembly, pursuant to the Constitution of the Federal Republic of Nigeria, particularly Section 109, subsection 1, paragraph G, even considering the proviso thereto, and the decisions of the Supreme Court that have laid the precedent based on the sacred principle of stare decisis. So we await the judiciary, including the Federal High Court in Port Harcourt, to make decision in that regard. And again, the Supreme Court that have adjourned for judgment on some of those appeals that have been heard yesterday, I do remember that I think one of the appeals has a connection with respect to the defection when a particular political party approached the Federal High Court before Justice Peter Lifu, requesting and demanding the court to order INEC to conduct elections to fill those vacant positions. I believe, and if I'm not mistaken, that would be one of the appeals that was heard yesterday.
I asked Mr.
So when we get to that point, then we'll have a complete conclusion of all of these matters in Rivers State.
Right. I asked simply because you go to the court and expect that the court will fix the situation in a certain time frame. So if we went to the, if these parties went to the court and tried to seek some sort of redress, and I'm talking spending time, a lot of money, this has obviously had its impact on governance as well, particularly this case in question. And after months, it's almost like we're back to square one. It didn't change anything. Shouldn't that concern everyone in question? First, the role of the judiciary, the role of legal practitioners as well, and of course the role of the politicians. It's almost like we just wasted the time of Rivers people, we wasted their resources, we wasted the precious time of Nigerians, only to come up with nothing.
Absolutely. Reasonably, there should be concern in regards to the actions of the stakeholders here. And I have identified three critical stakeholders: the judiciary, and of course, that's the bar bench, and then the political parties, and then the political office holder, public office holder. So I think we've come to a point where we need to actually separate those political interests of political office holders and the general and larger interests of the people when it comes to governance. But we are fortunate in Rivers State, I would say here, Kayode, that governance has been on since 2023 in Rivers State, not seriously impeded, but I believe that probably would have done much better because the administration of His Excellency, the governor of Rivers State, has gone on. I do not see the governor himself being at the center of all of this because at the time he had his challenge was when the tribunals were determining his fate post-election. So all of these matters appear to be matters of contestation as to the membership and leadership in the legislature in Rivers State, the Rivers State House of Assembly, not particularly in the executive. So governance has been on. Like we just discussed, the 2024 appropriation law has been implemented. And even as we speak, 2025 appropriation law is on ground. It has commenced. Enforcement is on, implementation of projects are going on.
Yeah. And indeed, Mr. Ekine, that's why, I'm wondering whether, this case dismissed by the Supreme Court is less important because it also bothers somewhat on the legitimacy of, the Amewule led state assembly and the continuing presentation and, transaction of business with a four-man Edison Ehi Assembly. But clearly it's an ongoing conversation, and the coming days will be telling about how, the courts would rule on the River State matter. Mr. Henry Ekine is a legal practitioner and national legal advisor of the Committee for the Defense of Human Rights, who has helped us to understand this case a little better. Thank you so much, sir, for your time on the program.
Thank you very much for having me. Always my pleasure to be on your platform and then to contribute to development in the areas of law and constitution and good governance. So much appreciated.
Thank you, sir.